As I mentioned earlier, copies of the presentations and slides will be sent out, so I do have some slides here, but I propose to skip through them and hopefully just give everyone some helpful hints regarding approvals. If you're on a committee, one of the many things you will do is giving approvals for various things, and they can often include lot improvements, people who want to add pergolas, solar panels, air conditioning awnings and the like. Some things to remember, committee has to act reasonably and also has to act impartially, so that if you've previously given consent or approval for pergolas or something like that, then you would need to have good reason to justify not giving it to somebody else. If you committee does receive, say for example, an application for a pergola, just because there are 10 or 12 of them already in the complex, if you're on the committee, you shouldn't tell the person, yes, that'll be fine, we've already got some of those, so go ahead. Firstly, it does need to go to a committee because it's a committee decision, as per the usually as per the bylaws. And secondly, even though you do give approval for them, you should impose approval conditions on those. Any improvement or approvals you give for improvements should contain conditions. As capital, we have a standard 7 conditions, I think it is. They're coming up now. Yeah, there they are there. And including that the lot owner has to comply with the conditions, they need to get council approval prior to commencing work. And this is very relevant because there might be things in the development approval that the developer got that will impact upon what the owner wants to do. So they need to get the body corporate approval, but also the city council approval where required. And the other, as I said, they're the standard conditions there, and we may indeed impose other conditions depending on, in consultation with the committee, depending on what's being asked for. We do have a form on our website where owners can submit their application, and that's then passed on to the committee. And if any further information is needed, then we go back to the applicant and ask them for that. For those of you who get from time to time the funny emails that tend to float around, you may have already seen this one. That is a high-rise building, I believe somewhere in China. The top part of that is a penthouse, and according to the email that went around, the penthouse owner applied for approval to install an air conditioner and also to make some minor landscaping improvements. What the body corporate ended up with was as follows. The air conditioner is circles, so they had actually put the air conditioner in, but as you can see the landscaping included rock and soil, etc., and I believe caused all sorts of problems to the foundations of the building. How they got up there is anybody's guess, but I believe they can build high-rise buildings in China in about 4 weeks. I suppose it presented no problem getting a bit of dirt onto the roof, and I guess they use the same process to get it back down. So that's an extreme example as to why you should get some conditions on your improvements. As has been alluded to a couple of times, under the standard module, there is a 7-day period of limbo where after the minutes go out, where nothing can happen in case the owners want to object, but that does require 50% of the one half of the owners to object within that period. And insurance is also dealt with here with improvements. As I said, you'll get a copy of the slide with that in it. As it says there, review the body corporate bylaws when getting a request. In particular, if you're in the Brisbane area, enclosing of a balcony to make an additional room is always restricted, in fact forbidden under the bylaws. And that's a city council requirement. They've gone as far to, they won't sign off on a CMS unless there are conditions in there, because you're not supposed to enclose balconies. So again, the committee needs to go back to the bylaws and just make sure that whatever they're approving is in fact that they're able to approve it. I'll skip the solar panels. Okay, pets. We could have a whole seminar on pets. It's been done to death over the time. The current state of play, if I can sort of summarise, a bylaw that is a blanket prohibition of pets will be struck down by the Commissioner's office. They're you can't use the word illegal, but they won't be enforced if the body corporate tries to enforce them. You can have a condition whereby pets are approved on certain conditions, and can I say that that is what you should do on all occasions? Approve them with the conditions, and then if the owner via the animal breaches those conditions, then the approval can be withdrawn, and in extreme cases the owner can be asked to remove the offending animal. Some of the conditions are set out there. As you can see, we have 9. I'll particularly refer you to number 2. The dog shall not be permitted to roam free at any time on the common property. I'd like to now apologise on Josephine's behalf. She had to leave early. As I mentioned earlier, we've moved into a community title scheme. We had a phone call about an hour ago saying your dog is wandering the common property and barking at people, please fix it. So Joe had to go home and get the dog. So she does apologise. She was had to say hello to a few people, but keeping our neighbours happy was sort of a bit paramount at the time. So that's why she's no longer here. But there are our standard 9 conditions for approval of pets, but again, there are others which, depending on the type of pet and the type of property you have, then you may need to add to those. And as it says there, if you don't, if you sort of throw up your hands in dismay and say, oh, who cares, we'll just approve these things, then you don't know, you might get an animal which you hadn't bargained for. So it isn't a lost cause for committees. You can still have some restrictions on what the owners do with their pets, and as I said, if they aren't good pet owners, then ultimately you may be able to enforce the bylaw and approval conditions and have the offending animal removed. And as you can see, we're equal opportunity there. There's 1 dog and 1 cat, so we don't discriminate against either. Also with pets, the application can be submitted online. That's their application form there. One of the conditions which I missed before is that the approval only relates to the specific animal, so that if the owners bring in dog A and dog A passes away, they can't immediately have dog B, so they do need to make an application again. And often what some people are doing now is sending in not only details of the animal, but also a photo so that it's identifiable as their dog, which probably isn't a bad idea. And one other condition which is in every bylaw, I think that has them, but I believe there's a decision around the present time saying the dog can't exceed 10 kilos when fully grown and so many centimetres at the shoulders. I understand that's now being considered as not a reasonable condition, and that people can have animals of pretty much any size provided they are behaving themselves. On the